Okay, so welcome everyone. We'll just start with a quick round of introductions for Michael and I, and then we can kick off into our GC know-how session, and we're talking about negotiating funding round term sheets today. So just a bit of background about me. I'm a senior corporate consultant at Ignition Law. I work with founders and investors on a broad range of corporate transactions, which range from fundraisings, M&A, restructurings, and exit. I've had big law experience at Allen & Overy before, for about a decade or so before I decided to focus on the startup and scale-up sector. I'll let Michael introduce himself and then maybe we can kick off.
Hi, I'm also a senior corporate consultant working on a sort of similar range of work to Karishma. My background is I was at Herbert Smith Freehills for a number of years, and then worked today at a Russian law firm for a number of years, doing sort of M&A, joint ventures type work, and then switched to doing the sort of startup scale-up work at Ignition about 18 months ago.
Great, thank you. So today we'll be looking into negotiating funding round term sheets in some detail. We'll go through some key terms where we see reasonable and unreasonable positions being taken, how to push back, and where it may not be worth it. We're not looking at M&A term sheets in this session, just to sort of set it out, but we'll focus on the funding round ones. If we just move on to the next slide. So just sort of setting out what we'll cover today. So we'll start off with just setting the market picture and in the global context, touch on the purpose and importance of having a funding round term sheet, delve into some key negotiating terms, and then just share some final thoughts or experiences. And we're very happy to take questions as we go along. So feel free to raise your hand on the system or to interrupt us. We're happy for that to happen. And then negotiations of funding round term sheets, like any negotiations, are sort of set in the context of the market and your bargaining power as an investor or as a founder or an issuing company will to some extent depend on whether it's an investor's market or an investee's market. So just looking at that and with some data in the next slide. So the global venture dollar volume in Q1 in 2024, the market's been a bit up and down in the last year after the sort of post-pandemic surge, which sort of made things go up. The dollar volume in the venture world dipped towards the end of 2023 and has picked up slightly at the start of this year. But Q1 24 is still lower than Q1 in 23. Just taking the sort of the bit about the early stage companies in the next slide and focusing on that, we see, if we just go to the next slide, we see that the money invested in early stage companies has actually increased, even though the number of deals has declined. So that's interesting. And in the next slide, we see that the seed and the angel investment also seems to have sort of held up better than the late stage companies. So it's just worth bearing the overall picture in mind and consider, where on the spectrum your company or the company that you're investing in falls into while going into your negotiations. It obviously also depends on the sector. If it's a hotly invested sector, then companies have a bit of an upper hand. Generally, investors like to, feel like they've got a higher bargaining power in a sort of context of fundraising because they're the ones putting in the money. But there are these factors that have a good play into it. Moving on then, coming back to sort of the legal side, we often get asked if a term sheet is required when a funding round is happening. Is it really necessary, especially when you're in your angel investor or pre-seed investing rounds? And the answer to that is it's not a legal requirement, but it's highly recommended. It's a great way to relatively quickly agree some key principles. because that would get your relationship started. We have seen deals fall away at the term sheet stage because when they started, when parties start putting words on a sheet, then they realized that actually what they both thought that they were agreeing to was different from what the other person thought. So it is definitely worth putting down in some key bullet points what you want to agree. It lowers the chances of surprises later. It's especially important when you've got large, several investors coming into the transaction together. So when you're doing a round, typically you get one lead investor, but then you have others who join in. The term sheet is a good way of, the lead investor will take the lead in negotiating the term sheet, but it's a good way to get it around the group so that people, sign up to the key terms and it doesn't come up later where you're ending up negotiating with 5-6 different parties on different terms.
And just one point to add there is you do need to be obviously careful at the term sheet stage as well, because the investors are going to treat this as a sort of binding document. Even if it isn't legally binding, they'll treat it as morally binding and it fixes the terms of the deal. So if you go into it sort of unprepared and just think you can agree things and then renegotiate them later, you can often come unstuck during the negotiations and find out you haven't got the flexibility you expected to move positions later. So you do need to give the term sheet some careful thought and consideration.
Yeah, absolutely. We've seen sort of several transactions where you say it's not binding, and this is the thing about the term sheet, sort of knowing that it's not binding in all respects. So there are certain provisions in a term sheet that will be binding, things like confidentiality and governing law and things like that. But the key commercial terms will not be binding, and so there's a temptation to say, right, it's not binding, we'll figure it out in the documents later, we can always change it. But as Michael said, it can come and bite you later on, because we've had lots of legal discussions where it says, right, it was agreed in the term sheet this way. But also it raises a point about what's not in the term sheet, because it's meant to have the key terms, and so a lot of terms are not, you wouldn't go into all of it. But often we find people saying, right, you didn't raise it at the term sheet stage, and so it wasn't important to you. So it's just being mindful of what is there, but also what's missing. Then moving on to the next one, it's just it's the first step in the process. If you don't have it, you can go into substantive transaction documents. And depending on the complexity of the investments and how far apart the parties are on the first drafts, you often see the need for like a substantive issues list to coordinate and negotiate the positions. So our recommendation would be sort of the more you can agree upfront, the better. Because if you have a clear term sheet beforehand, then you don't, it makes it much easier to agree the final documents. Moving on then, just getting into some of the key terms that we thought we'll just pick out in funding round term sheets. So we've just listed them, but we'll go into some detail around these. So investments, SEIS considerations in the UK, conditions that we see in term sheets, board decision makers and matters, reserved matters, share rights. Just moving on then. New issuances and anti-dilution, transfers, founder shares, restrictive covenants, and information rights. In the group we've got here, if anyone sort of has anything else that they would like us to cover, then very happy to pause and see what we have. Okay, we can move on then. We'll just try and cover everything quickly. Investment and valuation. So probably this is one of the most kind of important terms about how much is being put in and what's being given in return. It's really important to be clear around whether the valuation being used is pre or post money valuation, as this can sort of significantly affect the investors' shareholding percentages, as well as the founders. The share class is also important to discuss here. So this links into other provisions like liquidation preference and economic preference. So we would always advise clients to try and put a quick capitalization table, even if at the term sheet stage, maybe as a schedule or something very quick, to set out what the cap table would look like once the investment's gone in, which would then be quite clear around, what the valuation is, who's getting what percentage, and what share classes, and what the rights would be attached to them. Which I think nicely leads on to the next one, which is SEIS and EIS investments. So this is for early stage companies, a scheme in the UK for UK investors, where they can get a good tax advantage if the company is eligible to take SEIS or EIS investments and has registered for it. Investors are often advised to seek, some undertakings by the company to say that they will take reasonable efforts to get advance assurance, which is required for your SEIS or EIS investment eligibility, and to maintain eligibility so that the investors can sort of continue to benefit from it. I think in my experience, at least, it's not unreasonable for investors to take that position, and we see that quite often. But as a company, we would advise you to sort of make sure that it's limited to reasonable efforts and not best efforts, because best efforts in UK law has a different meaning. It could mean that the company is obliged or sort of undertaking to harm itself potentially commercially while making these efforts. So it's just sort of have a think about the wording on the page, but it's not unreasonable to ask for some comfort as an investor if they are making the investments on the basis of EIS or SEIS. You also see that you can have both SEIS and EIS investments, but then we've got to be careful around the wording of it and timing of when the investments close, etc. Just moving on then, some conditions that we find in term sheets. So there are some general conditions. So you'd see term sheets would be subject to the definitive documents being agreed. We touched upon SEIS, EIS investment, advance assurance, and eligibility. Due diligence and KYC, that's quite common as well, because when you're at your term sheet stage, the investor hasn't finished all of their due diligence and KYC necessarily. So it's subject to it, but it should, when you're signing it, you should be in a kind of stage where you've started something, so that you've got some assurance that it's the right business for you from an investor perspective. And as a company, again, having your ducks in a row on the diligence side, being ready to provide those documents that an investor would typically require would be good. Corporate consents. So these are the consents that would be required when you're taking on investments as a company. So things like your board approvals and shareholder consents and things like that. They are corporate formalities, but sometimes they could be issues around getting your preemption rights and things like that sorted if you've got a lot of investors in the company already. And it depends on sort of how broad your shareholder base is. So it's just worth keeping that in mind, that these are things that in the term sheet you would just say it's subject to all of that, which would be sorted in the future. These are all reasonable. We find them quite commonly in term sheets. On the next one, we've got some additional conditions, which are things like service contracts. So if key individuals are in the business, investors might want to say in terms of the terms of the contracts and salaries. They may ask for sort of terminating existing agreements, and then assignment of key IP, founders and key shareholders who have been brought on to provide expertise from a company perspective. All of that IP is usually assigned to the company if it's been prepared for the company. So it's, again, depending on the business, you might have additional conditions that are required. And it's, again, a good idea to just set them out in the term sheet. Moving on then, just looking at decision making. So decision making at the shareholder level is driven by the cap tables and the percentages that are owned, the classes of shares. So you may have preference shares, but also there may be shares where, the ordinary shares, but a different class where you've got voting rights and no voting rights, and reserved matters, which we'll touch upon in this session. The second level of decision making is at the board level. So whether an investor can have a director on the board becomes a negotiating point. Usually we see that an investor majority can have one together. So if you're doing a round where there are sort of a group of investors investing at the same time, they would have the same class of shares, and we would say that the majority is the investor majority, and typically that's 50%, but it's again subject to negotiation, would have a right to appoint one director between themselves. Sometimes there's a key investor who wants a right to a board seat for themselves. As the founder or issuing company, it's a good idea to try and link that right to a percentage. So if it drops, then because they're diluted or someone else comes in with a higher percentage, then that right is lost. So linking it to a percentage may be a good idea. Observers are also quite common. It's a way of sort of keeping an eye on the decisions that the board makes without swaying them and having a vote in the board. It's often used as a way to get information from the company without complying with directors' duties, because observers are not directors and they wouldn't have the same duties, but then they also don't have the vote. So there's a sort of balancing act there. We would always sort of suggest that if it's possible, have an odd number of directors on the board. So it's easier in terms of deadlock situations. If it's an even number, it's not a problem. But then we just have to think about what happens in a deadlock. Does someone have a casting vote as a chairperson? Usually boards don't like that because it can be a little sort of seen as a bit unfair. But ultimately it kind of goes on the percentages of the shareholders as well. So if the board can't agree, then do you leave it to the shareholders to use their sway on it. But from a board perspective, I think how many directors you've got on the board, who has the right to appoint them, and the observers are the kind of key points that we see negotiated in a term sheet. Moving on then to reserved matters. So this is a kind of highly negotiated list. Sometimes it's a way to protect minority shareholders. So in company law in the UK, you would have certain matters that shareholders could take at, like, using their majority of their shareholding. So at 50%, they could pass an ordinary resolution to take certain actions for the company. And then certain matters, you need 75% for special resolutions. So the Companies Act sort of sets out those thresholds for certain things that the shareholders could do as a group. But the way reserved matters would work is you're agreeing as shareholders on top of what's in the Companies Act between yourselves as to having a list of certain things that you would need consent of from shareholders. So it's like a veto right, which gets triggered at a particular percentage. So if you say set 80% or 75% as your threshold, where you need certain matters to be approved by 75% of shareholders in the business, then that's what you would need because it's an agreed list. You often see investors coming in asking for a list of reserved matters, and this is on the basis of an investor majority threshold, which we do see 50% used as that. So 50% of the shareholders voting together would have to approve those matters. For these matters, there's some sort of standard matters that we see in here, which are things like you can't change the articles of association, winding up of the company, providing dividends, things like changing the share rights, which we would consider are reasonable asks from when you've got your sort of investors beyond your friends and family rounds. So when it's friends and family, co-founders agreements, we do see reserved matters sometimes, but it's not uncommon to just keep it simple. You don't have reserve matters. You go with your shareholder majorities. Sometimes investors ask for sort of a personal veto on matters, and that's something which is seen as going beyond the reasonable, and companies would be advised to sort of push back on that. If they are taken together, then the minimum percentage of the shareholding that investors would have would be, say, about 10% or so, from our experience. The main thing, I guess, is the day-to-day running of the business. So the point of the reserve matters is where the board is taking decisions to run the company. Reserve matters are certain decisions that the board would, every time it needs to do those, go back to the shareholders to take their consent. And you can agree a list, but it should be like the key strategic kind of things in that list, rather than things that would hinder the day-to-day running of the business. So from a practical perspective, you don't want the company to be stuck with an unreasonable list of things that hinder that. So every time they would need to do anything that's in the ordinary course of business, the board should be allowed to do that without needing to go back to shareholders. Just moving on then, share rights. So the three key things in a share rights context are dividends, return on capital, and voting rights. These are, usually ordinary shares have all of these rights. Sometimes you could have different classes of ordinary shares that exclude some rights, or have dividends and return on capital, but not voting rights, depending on what the situation of the company is. We do sometimes see investors asking for an MFN, or a most favored nation clause. What that means is, if there's a future fundraise, then they get higher ranking shares, or they can get a right to convert into those shares. Pushing back from a company perspective on most favored nation clauses is quite common. So we see these being asked, and then from a company perspective, usually sort of they get crossed out. One thing to bear in mind is SEIS and EIS considerations. So if your company has SEIS, EIS investments, then HMRC doesn't like preference shares. So that would be something which, you can't have preference shares. What you can have is liquidation preferences within ordinary shares. But it is complicated in the sense that we would need to be very careful about drafting those provisions and making sure that they don't fall foul of the HMRC expectations. Then just moving on to dilution and anti-dilution. So one way to prevent dilution, or have a say when the company is sort of raising more capital and the existing shareholders are getting diluted, is preemption rights. So when new shares are issued, then it's very common to have preemption rights where all the existing shareholders would have a right to participate pro rata in the new shares, so in the issuance of the new shares. It's something which is in the model articles. So every company that's incorporated with model articles would have that, unless they've disapplied them themselves. It's quite usual that if you're going through a funding round, then you would replace the ones in the model articles with your own set of preemption rights. But it's quite common to say that, pro rata, they're offered to the existing shareholders. You can build in exceptions. So if you know that you're going to raise more capital while doing a round, then you would build it in, saying that we've got preemption rights, but we all accept that these situations wouldn't count. So if there's a known fundraising, you could say up to this amount, or you can put like up to this amount in the next year, or whatever you've agreed. You could also make an exception for share options. So it's quite common to agree that the company is going to be issuing new share options for its employees in the coming future. So you build that in, so you don't have to go and get or offer those shares to everyone in terms of the formal preemption process. And then usually there's an oversubscription mechanism built in. So if someone doesn't take the preemption offer, then the other shareholders might have a right to oversubscribe and take like more than their pro rata amount. And then I'll just mention that it's, usually the preemption process is quite a formal process that's built into the document. So there would be, it has to be offered, there's a notice period, people have some time to take up the offer, all of that. But we see that in practice, if the shareholders are all on the same page, then an informal and a practical preemption process is often used. So what that means is that you ask your shareholders, are they interested in taking the offer? And if they're not, then you can disapply the preemption rights using a special resolution. And if they are, then if they are interested, but they're not going to object to the kind of the formal process being used, the formal process not being used, then you can do the disapplication and then just include them in the round for the bits that they want to kind of invest in. There are other ways of anti-diluting. So there are mechanisms, and especially as you move towards higher rounds like Series A and B, there are a number of sort of anti-dilution mechanisms that operate to protect investors on a down round. So where the price goes down in the next round. And these vary in terms of how much protection the investors offered. It could range from a full ratchet, which provides investors the maximum protection, to, it could be a weighted average mechanism. Just to sort of, we would have to do like a whole session on these, and there are a formula that we could go through, but just to sort of quickly say that in terms of the range, the full ratchet is, in our experience, sort of seems a bit aggressive from an investor perspective. It's usually considered that the weighted average approach is sort of considered the fairer one in the market. So we see that being used more than the full ratchet. Just moving on, I think Michael is going to cover some of these pieces. So I'll just hand over to him, but any questions before we do that, I can pause.
Okay.
Over to you, Michael.
Yeah. So yeah, just continuing to look at the share capital and questions around that. The next point look at is the founder shares. They're not necessarily going to be a different class of shares to the investor shares. They may just be ordinary shares, but they're generally treated slightly differently. What the investor is going to want is the founder to be committed. The investor is obviously putting money in and has an investment horizon, that he'll want the founders to be committed to the company for a period as well, to ensure that they're there to secure the company's growth. The way that's usually achieved is through what's known as a reverse vesting mechanism. So the founders will have all of their shares from the start, and they'll have all the rights attached to those shares. But those shares will then vest in accordance with an agreed vesting schedule. And what that means is if the founders were to leave the company before those shares are fully vested, then there are consequences in terms of the shares they're allowed to retain, the shares that get forfeited, and the price at which they get transferred. So in the term sheet stage, you're probably looking at a few points being detailed in there. First point would be the vesting schedule. The second point would be sort of the good leaver, bad leaver definitions, which then plays into the consequences that would apply where a founder leaves. So looking at the vesting schedule first, I mean, typically the shares are going to vest in agreed percentages, either annually or quarterly or monthly, or sometimes you might have a hybrid mechanism whereby say for the first 2 years, an agreed percentage vests at the end of each of those years, and then you switch to a monthly or quarterly vesting schedule for the remainder of the period. From a founder perspective, what you want to make sure is that if you've actually invested money from the start for your equity, it's not gone in as debt, it's actually gone in for the shares, you'll want to make sure that you're not putting all that value at risk immediately. So you'll want to have an agreed percentage of shares that vest from the start, and then the remainder of it will vest in accordance with the the schedule, the investor is obviously going to make sure that the founders remain committed to the company for an extended period, and that therefore they're not getting too much equity up front. The other bit that's heavily negotiated is the sort of good leaver, bad leaver provisions. So these are going to, whether someone's a good leaver or a bad leaver when they exit the company, is going to have consequences in terms of their vested shares and the price at which they're transferred. Good leaver typically means that you've been made redundant or unfairly dismissed. Bad leaver would usually be dismissed for cause or resigning. But then in bad leaver as well, it's often fairly heavily negotiated. There's often a whole category of different breaches that an investor would want to use to designate someone as a bad leaver. So you're looking at breaches of contract, breaches of restrictive covenants, possibly issues around competency where someone's been dismissed. Now, as a founder, what they'll want is a very specific list of bad leaver options, and then everyone else is a good leaver. The investor is likely to come at it from the other way and say, unless you are specifically a good leaver, you're automatically a bad leaver. And I suppose one other point from a founder perspective is that where someone's being dismissed is usually the decision of the board. If you're at a stage where the investors are controlling the board, you're effectively meaning that the bad leaver decision, the bad leaver designation is in the hands of the investors. So you'd want to try and build in some additional protection there, whether that's a decision being supported by a decision of counsel. So you go to a barrister who would then have to find that there was evidence of fraud or dishonesty. Or alternatively, if you've got independent non-execs on a board, you could require that a bad leaver decision is supported by those non-execs as well. It just builds in some additional protections for founders and stops us being completely at the discretion of the investors. Because the good leaver, bad leaver distinction is very important in terms of what value the founders will extract from the company on an exit. Typically, if they're designated a bad leaver, any unvested shares are going to be turned into deferred shares, which basically means no economic rights and no voting rights. The vested shares, as a bad leaver, would typically be subject to transfer at nominal value. So effectively, that you're getting zero value for those shares. In a good leaver scenario, the founder is either going to be made to transfer the shares, but at fair value, so getting what's then a fair market price for them, or alternatively, they're allowed to carry on holding their shares and just exit in the ordinary course later on. And the investors' approach to that is really going to depend on the nature of the company and how they see it being run. In a smaller company, they may not want exiting founders to be sticking around as shareholders. You've got a very small shareholder base. They'll want to buy out those shareholders and just get them out of the picture immediately. With the companies a bit further down the line and you've got a wider shareholder base, they may be happy for the good leavers to sort of stick around and just continue to hold shares. Sometimes they'll want to remove some of the rights attached to those shares, so they'll strip away the voting rights, they'll remove any right to a board seat. But essentially, they'll be able to sort of realize the value from those shares at a later stage. So the next slide. Yeah, so share transfers. So you'll have some general provisions here, which will apply to all share transfers. So the key one here will be signing a deed of adherence. So on any transfer of shares, you'll want the transferee to be bound by the shareholders agreement. So any share transfer is likely to be conditional execution of a deed of adherence. And there'll be some other sorts of generic provisions around that, most of which won't be detailed in the term sheet. In the term sheet, you are likely to flag a couple of categories of transfers, which are sort of outside the ordinary course transfers, if you like. One of those would be a category of permitted transfers. Now, these are there essentially to allow individual shareholders to structure their investments particularly with a view to tax. So in terms of individual founders, they will be able to transfer shares to a qualifying company, being a company that they own or which is owned by all of their close family members. They'll be able to transfer shares to sort of close family members or to family trusts. And then for the investors and the corporate shareholders, they'll be able to transfer shares within their group or within the same fund group. And if a share transfer falls in one of those permitted transfer categories, then you don't have to follow the other share transfer provisions, which I'll come on to shortly. There's then going to be a category of compulsory transfers. I've already mentioned the leaver situation, so that's one of the key compulsory transfer events in a shareholders agreement. You'd also expect to see compulsory transfers for breaches of the shareholders agreement, and potentially also where there's an insolvency or bankruptcy event affecting a shareholder. And typically on those types of compulsory transfers, you'd have a transfer at nominal value. It's not going to be fair value transfers in those situations. So assuming that you're not within one of those categories and you're just a shareholder looking to voluntarily transfer your shares, then there's usually a series of processes that you need to follow. The detail of them, the actual mechanics and the notices that are served will all be matters for the definitive documents, but the sort of outlines and the principles behind it will be set out in the term sheets. Now, you're almost always going to have a right of first refusal on share transfers, and that's similar to the preemption rights that Karishma noted in the context of new issues of shares. So where you want to transfer shares, you'll have to offer all of those shares to the other shareholders, and they will have a right to take them up pro rata to their shareholdings. Sometimes that's done via the company, with the company acting as agent and being at the center of the process, sometimes not. You would have often have a right for, if shares aren't taken up by any shareholders or offered to, the other shareholders would be able to take those up as well. From a selling shareholder point of view, what you would ideally want is a situation whereby if all of the shares aren't taken up through the right of first refusal, the right of first refusal doesn't apply and you're able to sell your shares to a third party. Because what you won't want is a situation whereby you're selling, say, 30% holding, and then that gradually gets chipped away down to 7%. And suddenly there's a very different difference for 30% holding and 7% holding, and perhaps your original buyer isn't going to be interested. So you'd ideally want to make it an all or nothing arrangement, but it really depends on sort of the negotiating power, whether that is agreed or not. And that might be something that you come onto in the definitive documents rather than in the term sheet. And then once you follow the right of first refusal, depending on the shareholder being transferred, you can have a pair of rights which are normally looked at together. So tag along and drag along rights. Tag along gives a right for remaining shareholders to participate in a sale to a third party by another shareholder. A drag along right is the opposite and allows the selling shareholders to be able to force the remaining shareholders to sell their shares. They're pretty standard rights, and you would expect to see them in a term sheet. The bit that's usually debated is the percentage triggers for those rights. In a tag-along situation, usually you would, as a remaining shareholder, you would want to be able to exit where there's a change of control, because you don't necessarily know the approach that the new controlling shareholder is going to take to the company. You might want to stick around, so you'd want to have an exit right at that stage. For a drag along, it's usually at least the majority transferring, so at least 51%, you'd say. Very often it's a higher threshold of up to 75%. Sometimes investors will try to attach additional conditions to the drag along right, so they may not want to be dragged unless the sale is going to achieve a particular IRR. And I think in all cases, shareholders are not going to want to be dragged unless the sale is a sort of bona fide sale to a genuine third party. They'll want to try and avoid arrangements whereby there's a friendly sale at a lower value and they're dragged along, obviously not realizing the full value of their shares. And then just one other point to flag there is you sometimes see a co-sale right as well, which is a sort of variant on the tag-along rights, but usually rather than a complete sale of the shares, that would be a sort of pro rata sale. So say someone's selling 10% of their shareholding, a co-sale right would give the other shareholders a right to sell 10% of their shares as well. And it just gives, rather than securing an exit, it just gives other shareholders an opportunity to generate some liquidity from their shares at the same time as the other shareholders. To the next slide. Yeah, so that covers all the share capital points. The next few slides are covering a couple of points that investors are going to be keen to see in the agreement. One of them is restrictive covenants. So as well as making sure the founders are locked into the business for a period through the vesting arrangements, they're going to want to make sure that the founders aren't competing with the business at the same time, either during the term of their shareholding or afterwards as well. In terms of the actual covenants themselves, are pretty standard, and there's not usually a lot of discussion around them. I mean, the term sheet will usually say customary restrictive covenants, and they'd be non-compete, no engagement or involvement in a competing business, no solicitation of employees, customers, or suppliers. So they won't be going to any detail in the term sheet. The key point here is what's the interest that's being protected, and that will come down to the definition of the business. So from a founder's perspective, they'll want to keep the definition of business as narrow as possible so that if they leave the company, they've got maximum flexibility to start a different business in the future. From the investor's perspective, they'll want to make it as wide and generic as possible so that they're capturing anything which may even sort of tangentially sort of compete. So that's a point that's going to be very heavily negotiated, and founders just need to be very careful that they're not sort of tying their hands sort of necessarily. Yeah, then you're going to look at who is actually caught by the restrictive covenants. I mean, pretty much always it's going to be that the founders are caught. But there may be circumstances where there are other shareholders who are involved who you'd want to capture. I mean, most sort of angel investors, seed investors are going to resist being subject to restrictive covenants because they'll want maximum flexibility to invest, and they're possibly already invested in multiple competing businesses. So generally speaking, it would be the founders, but you will see situations where they request to bring other shareholders within those restrictive covenants. The term of the restrictive covenants would usually be picked up in the term sheet. Now, to some extent, the upper limits of the term of restrictive covenants comes down to enforceability, really. So what you typically see, what we see is for the duration of the shareholding, and then 12 to 36 months after someone ceases to be a shareholder, and 36 months would be at the sort of very upper side of what you'd see. More commonly, you're looking at 12 to 24 months there. And you have some overlap here with the employment agreements, because as employees, if the founders are also employees, they're possibly also going to have restrictive covenants in their employment agreements as well. And there'll be a separate term for those fixed by reference to the duration of the employment. In an employment agreement context, the restrictive covenants are much more tightly constrained due to restraint of trade considerations. So we're looking at an absolute maximum of 12 months in that situation. But it's just something to bear in mind, just thinking about the interaction between those two. And then the final point of restrictive covenants is in terms of carve-outs. There's usually a standard carve-out for sort of minority shareholdings in listed companies that may compete, sort of want to 1 to 3% of a listed company. But what you might need to consider, and again, this depends on perhaps on the definition of business and how widely that's drafted, is whether you need any specific carve-outs as founders to cover any other businesses that you're interested in. And sometimes there can be a restrictive covenant on having any involvement in any other business, whether competing or not, as long as they're a shareholder, in which case you may well need some carve-outs to cover other interests.
Just to add at one point on the carve-outs, you often see that if the shareholders already have plans to have something else which might be seen as in competition, then you can kind of specify it as a carve-out, so it's not confusing later. I've seen that in a couple of transactions recently.
Okay. Let's on to the next slide. Information rights is another investor protection. The pretty standard ones that they're always going to want to see are some kind of financial reporting. Annual accounts are almost always going to be included and on a much faster timeline than would be required by the Companies Act. Any investor putting in sort of a significant amount of money is also going to want to see monthly management accounts, and probably in a form that they've approved, and perhaps with it being reconciled against the annual budget, and perhaps dealing with other KPIs and other metrics. So that's something which would be flagged in the term sheet. Investors are also likely to, if they're putting in a significant amount of money, may want some control over the annual budget, at least sight of that and approval of that. That will depend on sort of level of operation involvement that the shareholders are going to have. And if it's a smaller investor, then certainly the founders would want to push back on that as being a point that's sort of linked with the reserve matters that Karishma mentioned. That would be something that would be sort of effectively an unreasonable veto for the investor. And then on top of that, on top of the financial reporting, I mean, if the investor's got a shareholder, a director rather, they're going to want to see board packs in advance of those meetings with an agenda and background on the items that are being considered at the meeting. They'll almost always include a point that they can be provided with information that they reasonably request. As the company, you would probably want to limit that to things that are required for sort of tax or regulatory compliance, so you don't just have ongoing fishing expeditions by investors. And then you sometimes see investors asking for the company to provide updates on all material developments. And again, that's something that as a company you probably want to push back on, because it can obviously become quite burdensome, and you don't necessarily want to be given a running commentary on every matter that the company is involved with and potentially sharing commercially sensitive information. So a couple of other additional provisions around the sort of information rights that you might see as sort of having tiered rights, whereby investors holding above a certain percentage of the shares get particular rights, but those rights will fall away if that percentage drops and if they're diluted. And investors will often seek a sort of step-in rights to be able to access the premises, the books and accounts, and the employees themselves if they're not getting the reporting that they're expected to get. On to the next slide. Warranties. At term sheet stage, I mean, this is pretty much just going to say customary representations and warranties, but in line with sort of BVCA models and sort of most investor documents, that the warranties are going to be quite full, and there's going to be a reluctance by investors to tailor them to the company, just because it's a lot of time and effort in doing that, and they want to use this as a mechanism to flush out information about the company. None of that is really going to be detailed in the term sheet, so it's just something to bear in mind, that when you're agreeing to customary representations and warranties, it will mean in the investor's mind quite a full set of warranties. the question is who's given the warranties will be dealt with in the term sheet. The company is almost always going to give the warranties. There's then a question of whether the founders are also required to give warranties. I mean, there is scope to push back on that. Sometimes investors will insist upon it because they would like particularly if it's a very new company, they'll want the founders to actually stand behind those warranties and commit to the company as well. Perhaps the liability cap is probably going to be different between the two classes of warranties. The company, it is pretty much always going to be 100% of the subscription proceeds are available to satisfy warranty claims. For the founders, it's usually fixed by reference to annual salary, and you see sort of 1 to 2 times annual salary is a pretty common limit in the market. And then Karishma has already touched on this earlier about the due diligence and the data room and the importance of having an organized data room. It really is absolutely critical. If you've got a very well organized data room, it doesn't have to do anything sophisticated. It just be a Google Drive or SharePoint. But if it's well structured, organized folders and well indexed and everything sort of in there from the start, and you're not sort of drip feeding information to investors, it just gives the investors the confidence that the company's being well run and that they're getting full disclosure and they can be confident in what they're being told. And that then feeds into the disclosure process as well. So the disclosure process is where the company discloses against the warranties any matters that would be a breach of warranty, and that prevents claims being made post-closing. And if you've got a very well organized data room, it makes that process a lot smoother, and it makes it much more likely that the investor is going to accept disclosure of the entire data room because they've got confidence that they've seen everything that's in there and it's not just documents being added sort of day by day.
Just one point on the warranties, which is that I think the latest British Venture Capital Association documents, they got revised last year, I think 2023, and in their new versions, they've got only the company giving those warranties. So it may be like a negotiating tactic if you're acting for the company to sort of say that the latest standard BVCA documents don't have them from the founders.
Yeah, and you do see a distinction between the sort of the British VC market that seems to accept that it's just the company, but if you've got overseas investors, there's different approaches. I've sort of Middle East investors I know have sort of insisted on the founders standing behind the warranties as well.
Yeah.
Okay, I think onto the final slide. These are just a few sort of boilerplate provisions that we include in the term sheet. One is confidentiality. This would usually be just the confidentiality relating to the provisions of the term sheet and the negotiations. So you probably end up with a standalone NDA between the company and the potential investor to cover the data room and the disclosure of the documents there. Binding effect, I think Karishma's already touched on this earlier, that you'd have, for the most part, the term sheet is going to be non-binding, so it'll just have just morally binding. Yeah, but there are a few provisions that you'd sort of pick out that are going to be binding. One would be the binding effect clause itself. The confidentiality provision would usually be binding. Anything around fees would usually be binding, and then the governing law provision is going to be binding. But for the rest of it, it's just morally binding. And the reality is that if you negotiate a term sheet, even if it's not legally binding, if you then try and sort of deviate materially from those terms in the negotiations, you're probably going to find that the deal will just fall away. So it does have some effect. Fees. Here, I mean, it will usually, it's quite common for the company to be required to cover the investor's fees for the transaction, but you'd want to fix that up to an agreed level, want a cap on that, and that would often be fixed in the term sheet. And then governing law would be specified in there, and that's obviously relevant to the provisions which are legally binding, but it's also relevant to the provisions which aren't legally binding, because you're using terms like reasonable efforts, best efforts, etc. So you'll want to understand how those provisions are interpreted. And that's pretty much it.
Should we open for any questions or comments, experiences, anyone? I think just on the point about the fees, the one thing that, you know, if you're capping fees, we should also make sure that VAT and disbursements are included if it's applicable, and, you know, just specify that in the term sheet, because it could, like, later on become a point of contention otherwise.
It's Adam Vetanova from Eunice. I'm the COO at Eunice. We're a seed stage startup. In terms, and it sort of relates to term sheets, but it's even pre the term sheet stage, what would be normal in terms of what you actually disclose to the VC funds before you actually sign the NDA with them? Because obviously you go to a bunch of VC funds and say, I want to talk to you, here's what I'm doing. At which point you don't even have a binding NDA. And the point is, you can't, if you put a binding NDA in front of a lot of them, they'll just won't talk to you because they look at so many deals. So what do you see as the kind of common practice there?
You want to, you don't want to give away any commercially sensitive, anything which can be shared with competitors at that stage. You'd want to keep to yourself. I mean, you're obviously going to be able to need to disclose enough to sort of give a flavor of what you're doing, but without giving away anything commercially sensitive that they could potentially share with their other portfolio companies. So it's a difficult balancing act. You'd also want to be mindful of any existing confidentiality obligations that you have. So you've got an existing shareholders agreement as well. There's potentially confidentiality obligations in there, and you'll have similar obligations in contracts with suppliers and customers. So there's probably only a limited amount that you can disclose at that stage. I mean, you'd ideally be limiting it to sort of publicly available information, and perhaps it's just a question of sort of collating what's publicly available in a more sort of accessible format. But really, you'd want an NDA in place as early as possible.
Yeah. Okay. And and that's typically before you even start negotiating the term sheet, right? You want to just put an NDA in, and then you.
Yeah. Well, the term sheet provision, the term sheet would usually have a confidentiality provision itself, but that's not really covering the data room side of things.
No,
yeah,
that's fine.
Yeah, and if you have a pitch deck, then your NDA is sort of sent around the same time, and then the pitch deck would have your headline items. But if they want more information to sort of test what you've got in there, then, you know, you've got to, you know, you can do it on a case by case rather than give it to everyone, because they could get shared around.
Perfect.
Okay, that's bang on 11 o'clock. So thanks everyone for joining, and see you in the other GC know-how sessions.
Yeah, thank you. Bye.
Thank you.
Thanks, guys. Thanks, everyone.